Hi, nice to see you again at the Utsav Mukherjee IP and Tech Law Show. The last few episodes have largely been about trademark law in India. Today's episode is about copyright. Many people who reach out to me actually confuse trademarks and copyrights. The truth is, both are quite different from each other and offer legal protection for completely different forms of intellectual property. So, to make it simpler, we can say that trademarks are brand names or logos under which goods or services are being marketed or sold, whereas copyright is the exclusive right given to the author of a particular creative work to use, make copies of, distribute, display, or perform that creative work. In today's episode, I will first tell you about what are the kinds of works that you can get a copyright on in India and what rights you get from such copyright. So, copyright law in India is governed mainly by the Copyright Act of 1957, and this statute is read along with international conventions that India is party to, as well as common law principles. Common law jurisdictions such as India are those that were former British colonies, where legal systems are largely based on English principles of law. So, what types of works can be copyrighted? For one, there are literary works. This means books, essays, articles, or even computer softwares. It could also mean something like a poem or a nice collection of short stories. So, anything that you write, you can get a copyright on, right? If you're the first author of that work. However, if you have produced that literary work during the course of employment of a publisher, say a magazine, or a publishing house, or a newspaper agency, then for the purpose of publication, they would have the copyright over that literary work, right? And unless you have an explicit agreement with them that says otherwise, which says specifically that no, you will have that copyright and not them. So this only applies if you're an employee for that publishing house, that publisher, right? And not if you have a freelance arrangement with them. So if you're a freelancer, you would have the first copyright on that literary work, unless you have an agreement which vests them with that copyright, right? So that's the difference between the natural rights in a copyright for a freelancer who produces a written work versus the legal rights and the copyright of somebody who is doing it in the course of employment, right? So very simple example: if you're working with the Times of India as an employee, and if you write for them, so if the first copyright will be with them unless there's an agreement to the contrary. But if you are, say, a freelancer and you're a freelance correspondent, a freelance writer with the Times of India, then as per law you would have the first copyright over anything you write, unless there is an agreement which says that Times of India would have that copyright. So that's the difference between copyright for freelancer and employee. Now, there are also artistic works, right? So this includes photographs, it includes paintings, sculptures, drawings, engravings. When I say drawings, it includes simple drawings like charts, diagrams, or maps. So you can get a copyright over these as well. In fact, I was once on a copyright case where the whole case was about conflict over who had the copyright over certain engineering drawings. So artistic works have a lot of copyright issues. Then we talk about musical works, right? So this is a bit interesting. When I say musical work, I mean the actual music, say the tune, right? Not the words that the song consists of. The music is separately copyrighted as a musical work, and the words are separately copyrighted as a literary work. And together, you get a copyright over the entire song, right? Over both elements, the music and the musical work, the literary work. If you consider them together, so you have a copyright over the entire song. Now, a cinematographic film can also be copyrighted, right? So it sounds complicated. Now, that's also complicated work, cinematographic. But it's actually a very simple thing. That this literally means that a movie can be copyrighted, right? That's because a cinematographic film is something which includes both a visual recording and the accompanying sound recording. And a lot of you might have heard about big copyright cases being filed by film production houses against the copying of their films. So that's where they get their copyright from, right? Now, while we're talking about films, I must tell you, even plays and scripts for dramas can be copyrighted under the head dramatic works. This is a separate head under the Copyright Act, right? From which you can get protection for such dramatic works, right? And that's enough about the various kinds of works that can be copyrighted in India. It's also important for you to know why you need a copyright and what purpose this serves. So once you have a copyright on something, may it be a film that you make, a novel that you write, or a song that you compose, nobody can use that creative work without your consent, right? For commercial gains or otherwise. You have to give explicit consent to them to use it. And they can only do these things if you assign the copyright to them or grant a license to them to use that work for a certain specified period of time or for a certain specific purpose. Now, if someone infringes upon your copyright in a creative work, you can sue that person before a court, get an injunction to refrain them from copying your work, and even claim damages for the wrongful gains that you have made using a copyright work without your consent. Now, in order to claim copyright, it is not compulsory under Indian law for you to register your copyright, yet it is strongly advisable that you do so, as this creates an official record of your copyright and serves as evidence in the event that you are compelled to actually go to court and sue an infringer, right? Also, one more thing that you need to know, copyright only subsists for a specified period of time, right? It is not forever. So, unless that is renewed or whatever, it has to be only for a certain specified period of time. It is not a forever right. And the Delhi High Court's IP division is great for copyright cases. I have myself been on a number of copyright cases before the Delhi High Court, right, where I've seen the court act in favor of the author of the copyright and grant protection to these copyright owners. And so, for any artist, any author, any publishing house that is out there listening, be on the lookout, please, for infringers and make sure to get legal protection for your creative work. Thanks and have a great day. Thank you.